Read a second time. I call the member for Newtown.
Thank you, Madam Speaker. I rise to speak on behalf of the Greens to the Bail Amendment Bill 2015 and the Terrorism Police Powers Bill 2015. As much as I am aware that this might draw criticism and yells from across the other side of the chamber and behind me, the Greens do not support either of the amendments to these bills, but I'll deal with them separately. The Bail Amendment Bill 2015 will add further complications to the assessments under the bail regime, making the application of bail less transparent, less consistent, and is not considered likely to improve the safety of residents in New South Wales in any meaningful way. It is our belief that this bill is premature. The coronial investigation into the Martin Place siege is ongoing and is considering the subject of bail in some detail. There seems little reason to push through these changes now, when only a few months another tranche of amendments will be required. The compulsion of successive Labor and Liberal governments alike to meddle with the bail laws is what has produced the previous scheme of bail, which was roundly decried for being overly complex and inconsistent in its application. While recommendations have been received from the Martin Place Siege Review, those from the coronial inquest will be of at least equal importance and have not yet been made. As such, this legislation is seriously premature in this regard. In June 2013, the Law Reform Commission report was tabled in the New South Wales Parliament by the then Attorney-General Greg Smith. That report described the New South Wales bail system at the time as voluminous, unwieldy and hugely complex, and said that the results are frequently anomalous and unjust. This report led to the new Simplified Bail Act. The Bail Bill 2013 was introduced into the New South Wales Parliament on the 1st of May 2013 and commenced on the 20th of May 2014. By the time the bill was implemented, the government had already been spooked on bail and ordered in June 2014 a lightning speed review by former Attorney-General John Tsitsigos. Now we see, with these amendments to the Bail Act, that we are moving back to the situation where the New South Wales bail law will again become too complicated, too unwieldy and too reactionary as a result of the media cycle. The interim report of the Tsitsigos review resulted in the Bail Amendment Act 2014, which created a new show cause test for adults charged with certain offences. For certain serious offences, the accused must first show cause why his or her detention is not justified, and then once this is satisfied, the usual unacceptable risk test is considered. This legislation creates yet more tests, adding unnecessary complications and tests for exceptional circumstances and show cause tests. Under both of these tests, the unacceptable risks test must also then be considered. The current unacceptable risk test is already broad enough and comprehensive enough to be used on their own. I give you some examples of what is already the scope within the unacceptable risk tests, including assessing the accused person's background, including criminal history, circumstances and community ties, assessing whether the accused person has a history of violence, whether the accused person has previously committed a serious offence while on bail, whether the accused person has any criminal associations, whether the conduct of the accused person towards any victim of the offence or any family member of a victim after the offence, and whether the likely effect of the offence on what the likely effect is of an offence on any victim or the community in general. As you can see from just some of these examples, close to 20 examples of what needs to be considered in the unacceptable risks test, they are already broad enough and comprehensive enough to be used on their own. I will now turn to address the Terrorism Police Powers Bill 2015. This bill seeks to stop the existing police powers in this bill from sunsetting in December 2015 and extend them for another 3 years. The Greens do not support this extension. Often sunset clauses like this are included in bills as a way of trying to suggest that the powers are only intended to be there for a limited time in response to a certain kind of threat. Often the sunset clause is a way of silencing those concerns about the impact that these powers will have on the community as a whole, on civil liberties and on human rights. They are used as a way of reassuring the community in a way that may sound something like, we know these are extreme measures, but don't worry, we are putting a sunset clause in. They are only for a temporary period of time. As far as we are aware, when it comes to terrorism and police-related legislation, sunset clauses like this have never actually set anywhere in Australia. Every 3 years, the department dutifully undertakes the legislative review of the Act, and remarkably, in each case, the conclusions are the same, despite the fact that the powers under the Act have been exercised only in extremely rare circumstances, and that the submissions received all raise serious concerns with the legislation and the safeguards in place. Nevertheless, the recommendation is the law should be extended. If there is a reason why these powers are required, if there are cases where they have been used to prevent harm to the community, why have we not seen evidence of this? Where is the evidence of where these powers have been necessary? What we have seen is people successfully charged and prosecuted for terrorism offences using traditional police powers, which were effective and gave police the scope that they needed. We have also seen, since the introduction of these powers, serious concerns raised by human rights groups, from civil liberties organisations through to those in the legal profession. Article 9 of the International Convention on the Civil and Political Rights requires that 1. Everyone has the right to liberty and security of person, and no one shall be subject to arbitrary arrest of detention. 2. That anyone who is arrested shall be informed at the time of arrest of the reason for his arrest and shall be promptly informed of any charges against him. Detention without trial is not acceptable. Anyone who is deprived of his liberty by arrest of detention shall be entitled to take proceedings before a court in order that that court may decide without delay on the lawfulness of his detention or order his release if the detention is not lawful. The government has provided no evidence to support the ongoing need for these laws or the efficacy over the last 13 years. The simple fact is that where terrorism laws and police powers are concerned, the sun never sets. I think it is an indication of the state of our community and our society that I feel a sense of fear standing up here to oppose the extension of these terrorism laws today. Because what we are doing, though, is we are standing up and we are saying that the existing ordinary police powers are there and that terrorism offences can be dealt with within the normal criminal justice system. But someone must be willing to stand up and say that in introducing and increasing and continuing these terrorism police power laws, that what we are seeing is a reduction on our freedoms, on our human rights, on our basic civil liberties. And it is for that reason that I stand up today and say that the Greens will not support the extension. We will not support these bills. And I stand with many in the community that expect the Greens and myself as a representative of the people of Newtown to stand up and say that this is not the way that we will address these problems, and we should not be curbing our civil liberties and our human rights in the name of so-called defence of terrorism.